Hi, everyone. Thanks for attending our presentation today on the importance of data privacy due diligence in mergers and acquisitions, protecting value, managing risk, and ensuring compliance. I'm Brittney Mollman. I'm counsel at Thompson Coburn in our St. Louis office. My practice focuses on data privacy litigation and compliance.
Hi, everybody. I'm Luke Sosnicki. I'm a partner in the firm's Los Angeles office. I'm a litigator. My focus is on mostly consumer class actions, including class and mass actions dealing with consumer privacy rights. And I also spend a good amount of time, certainly more time recently, advising folks on consumer privacy issues so that they can stay out of litigation, including in the context of transactions like M&A deals.
Hi, everyone. My name is Matt Misichko. I'm a partner in the Corporate and Securities Group at Thompson Coburn. I work out of our Chicago office. Most of my time is spent on both buy-side and sell-side deals in the M&A space. And obviously have the pleasure of looping in and talking with Luke and Brittney as need be on any data privacy and security and IT matters that come up during the various phases of a transaction. So thanks to all of you for being with us today.
Before we get started, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We're going to try to answer questions during the webcast, so feel free to submit them as your questions come up. If a fuller answer is needed, though, or we run out of time to address them, we can answer you later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of the slide deck is available in the resources widget. We encourage you to download any resources or links you may find useful. You can find additional answers to some common technical issues in the help widget at the bottom of your screen. Today's CLE event is today's event is CLE accredited in California for 1 hour of technology credit, in Illinois for 1 hour of general credit, in Missouri for 1.2 hours of general credit, in New York for 1 hour of cybersecurity, privacy, and data protection credit for experienced and transitional attorneys, and in Texas for 1 hour of general credit. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to those polls to receive full credit. And we value your opinions and appreciate your participation in today's course. Here's the agenda for today's presentation. We're going to start by talking about current regulatory landscape and why data privacy matters in mergers and acquisitions. Then we'll discuss pre-transaction considerations involving data privacy issues, tools to address data privacy red flags that come up during that process, and post-closing integration and risk mitigation. Then we're going to talk a little bit about a real-world example, Microsoft's acquisition of LinkedIn from 2016, and have some formal time for Q&A, but as I mentioned, we'll be taking questions as you have them throughout the presentation. So this slide is, I'm not going to go through in detail any of the regulations listed here. The slide is meant to illustrate the patchwork of laws and regulations globally that play into the data privacy analysis when it comes to mergers and acquisitions. Which laws need to be considered in detail will require thoughtful understanding of where your target resides, what data the target possesses, and how data flows within the target organization, how data flows out of the target organization to third-party vendors, and where the data resides, which is not always the same as where the target resides. On the buyer side, it's important to kind of know going into your deal, what are you valuing the data for? How do you want to use it so that during due diligence, you can account for all of the appropriate laws and regulations to ensure that you are getting the full value of your purchase. Okay. Why data privacy matters. Data privacy issues in M&A are often framed narrowly, sometimes too narrowly, just reviewing policies, reviewing contracts, and flagging international transfers of data that might occur. But thoughtful legal strategy calls for a little bit of a deeper and more forward-looking analysis, accounting for potential financial, legal, and regulatory risk. For purposes of the presentation, this slide, it provides some buckets to conceptualize the spectrum of issues we should be thinking about when it comes to data privacy and M&A. It's not a comprehensive list, of course, but it does highlight a lot of what we as Data Privacy Counsel are most concerned about when evaluating a potential M&A target for a client buyer, or on the target side, advising a client as a potential target on the receiving end of the due diligence. It's also worth noting that the categories listed don't operate in silos, but are often in relationship to one another. So, and this might be, obvious, but for the sake of an example, the unforeseen costs and overlooked liabilities that fall into the financial M&A risks category can be a symptom of overlooked regulatory or legal noncompliance. So a buyer needs to know what they're getting. Financial, as far as financial considerations go, weak privacy practices or noncompliance on the target side can lead to fines, lawsuits, and other issues that impact valuation, deal structure, or post-close integration costs that can be quite expensive. On the legal risks, that there we're thinking about outdated contracts, maybe a misaligned consent architecture, meaning looking for whether the target tells its end users what it's collecting, how it's using it, and how it's sharing that data. And if the consents aren't aligned, it can cause, again, overlooked potential regulatory noncompliance issues. On the regulatory side, regulators pay close attention, and especially in the highly regulated sectors like health, finance, and tech. Of course, regulatory investigations we know can end up in large fines, which are expensive, but also just the public enforcement, mandatory audit procedures. Those are time consuming and expensive. It can also limit how you are able to use the consumer data you just purchased in a way that, again, doesn't align with deal value. Finally, on the operational side, if the acquired company can't transfer or use the data as it planned, it slows down integration, marketing strategies, product development, customer onboarding, all of that can stall. And so, again, frustrating, but also costly. So having a thoughtful legal strategy kind of going into the deal is essential, really, to get the most out of your M&A deal. So now I'm going to pass it to Matt to discuss some pre-transaction considerations.
Great. Thanks very much, Brittney. And to piggyback off of that prior slide, I think from my perspective, when we are at the early stages of a transaction, one thing that's incredibly critical is how do we make sure we ask for the specific information that we need that was on that prior slide from Brittney during the due diligence phase. So from a practical perspective, for due diligence for data privacy reasons, right, we're trying to assess how information is collected and stored and managed. One thing I would say too is I think early on in the diligence stage, especially if you're on the buy side and trying to understand the business of the target, I think it's very helpful to understand like whether there are specific systems, whether there's specific software, whether there's specific data or information that is mission critical or material to the business. And the reason I say that is obviously there's going to be a laundry list of due diligence items that will span many different practice areas or subject matter experts. But what I can say from experience is I think it's imperative to not only have your initial due diligence request list that from the perspective of data and privacy matters, probably needs to be specified as it relates to me, a big bucket is whether there is actually personally identifiable information or personal health information or other sensitive information that is related to and critical to the target's operations. And that is much more of a subset of the more general due diligence requests that I think you would see in any transaction from a data and privacy perspective. How do you collect this data? What kind of policies and procedures do you have in place, right? Obviously, this slide gives a good overview of what we are trying to accomplish in the due diligence phase. And again, from a process, there's going to be the initial due diligence list, but I think more importantly, even when that list is sent to the target company for review and answers, as information comes in, I think it's imperative to make sure you have the correct internal team privy to the information that's coming in to be reviewed, and most importantly, to have follow-up conversations. So from my perspective, obviously, I just worked on a deal probably 6 or 7 months ago where there was a software related to the business in the medical and healthcare space that was vital to the business, and that software helped physicians basically create some sort of end product, and that software was receiving personal health information, right? So it was a matter of, okay, now we have an understanding of what this software is. What's the underlying agreement that is the relationship between the software and the third party who is providing that information, and then how does it get to the seller to produce this product? And most importantly, again, I think it's not only a legal question that needs to be assessed, but from a downstream perspective, when it comes to everyone's goal is to close this transaction, you need to understand what those business implications are, and we'll talk later in this presentation about integration. But most importantly, to be very clear, it's important to have the correct stakeholders on the phone talking to the other side to make sure everyone is on the same page. And to me, again, as a general corporate M&A attorney, it's very helpful to make sure that those individuals are having those conversations, because what it does is it makes sure that we're all speaking the same language. And some of this stuff is incredibly technical, and it's very helpful to have those people on the call to understand what gaps may be in place, what may not be up to par from a regulatory perspective or from a business operations perspective. And to me, due diligence can be sometimes seen as a static exercise, but I think it should be dynamic. And I think it should be continuous conversations. And I think specifically as it relates to the topics we're covering here today, it's much more important to get ahead of it and have a good understanding of what is at issue or what is at play or what is relevant related to the target's business, so that you understand from the buy side as to the full scope of the picture is the best way I would put it. Okay, then from, I guess, a little bit prior to the due diligence phase to an extent, one item we did want to touch base on, and we call this our practical tip number one, is considering how data is shared between the target and a potential acquiring entity during the due diligence process. So again, from my perspective as a corporate M&A attorney, during the letter of intent phase or even prior to that, there is very, very likely a confidentiality agreement that is in place between buyer and seller. And usually, I think there's a couple important factors related to that agreement. One is obviously, what is the scope of the information that is privy to this confidentiality agreement, right? That's typically very broad. It's going to relate to the proposed transaction that is being contemplated, whether it's a stock deal or an asset deal. I think even more importantly too is, or just as important, is the scope in which what individuals fall under the obligations of the confidentiality agreement, right? So typically what we'll see is not only buyer and seller, but their representatives are also subject to the confidentiality obligations. And that's going to include not only employees and independent contractors, it would include outside advisors, finance, legal, tax, and typically what I like to include too is like some sort of, agent. And the reason I say that obviously is it goes back to the example I had mentioned where a client had hired a third party to basically assess the vulnerabilities and information processing for software. And there was some hesitation from the sell side on allowing these individuals to have access to this information and conduct their work. And we were obviously able to, appease seller or make them less worried about the situation because those agents were covered under the confidentiality agreement as it relates to the proposed transaction. So from my perspective, again, I speak specifically to my experience and the need and the importance of a confidentiality agreement. And obviously, Brittney and Luke will touch a little bit more on a data sharing agreement here in a couple moments. But as the slide says, a couple other items that I think are very important to keep in mind when it comes to the potential of personally identifiable information being shared in the M&A context. I think this first sub-bullet is very important. I think it's also practically a bit difficult to navigate sometimes, to be quite honest. In the event there is an underlying agreement that possibly prevents personally identifiable information or confidential information of a third party to be shared with any other third party, i.e. buyer or seller, that agreement may require the prior written notice or the prior written consent of that third party prior to that information being disclosed. Sometimes you will see and hopefully you will see, and especially from my world, a carve out that says, hey, in the event of any acquisition or sale or merger, the confidential obligations related to this information is not applicable. Okay, but I think more importantly and more than anything, it's identifying what that underlying agreement is, understanding what the obligations are of the party that would be receiving this personally identifiable information or confidential information, and really buyer and seller having a conversation as to what is the best path forward in terms of next steps. If this information that relates to this underlying agreement cannot be shared, maybe it shouldn't be shared at this time, right? That obviously relates to this third sub-bullet here, where like there is absolutely a timing component when we are discussing personal health information, personally identifiable information in the context of a transaction. That analysis gets heightened if there were to be some sort of pre-existing relationship between buyer and seller. For example, if maybe seller is a customer of buyer already, then buyer is essentially getting, to an extent, a look under the hood at some of seller's business practices by way of a proposed transaction between seller and buyer. So I think there is absolutely not only a contractual and legal analysis that has to be done, there's also a practical analysis that has to be done where the parties are aligned when it comes to timing. And again, sharing too early means really just thinking about when is the best time within the context of the transaction in the aggregate as to when this information should be disclosed to certain parties. And with that, again, there's an importance as it relates to the confidentiality agreement providing a good foundation and structure for both buyer and seller as to what type of information can and cannot be disclosed. But I know Brittney and Luke have some insight and experience as to the additional protections that a data sharing agreement can provide as well.
Thank you. Yeah. Matt did a wonderful job covering the NDA's role in all of this. But where personal data is at stake or is being exchanged in the M&A deal, the NDA doesn't necessarily address the exchange of the sensitive data and regulatory and legal limitations on the use of that data. A good way to think about a DSA a data sharing agreement in comparison or in against a contract that most businesses are likely familiar with would be, kind of any third party vendor agreement where the relationship involves the sharing of personal data. Laws in the United States today, GDPR, have specific provisions requiring any company that you are transferring data you collect, and you're asking them to process it for your own business purpose or sharing it with them for their own benefit, requires some sort of vendor agreement placing limitations and structure around that relationship. And in the same way, when the buyer receives potential target data, there need to be those same limitations to ensure, both that the target and the buyer are remaining in compliance legally. So some categories of, I guess, data use that the NDA wouldn't address would be, that the DSA does address include processing limitations by the buyer that align with the target's consent architecture. Again, I mentioned that kind of a little bit earlier, meaning when the target collects data from its end users, it's required to tell them under current U.S. law what it's collecting, how it's collecting that data, and how it's using and or sharing that data. And so the use that the buyer is permitted under the data sharing agreement needs to align with that architecture. The data sharing agreement will also establish the legitimate business purpose, which is required under both GDPR and current US law, for why the information is being processed, though it may be obvious, right, for the potential deal. The data sharing agreement can also ensure highly sensitive data is anonymized or pseudonymized in accordance with consent, architecture, contracts, or legal requirements. It can impose safeguards for processing sensitive health information that is required under HIPAA. And then it can set forth any parameters necessary to meet audit or compliance obligations. So to kind of bring that practical, the acquisition we're going to be talking about in more detail later in the presentation, Microsoft acquisition of LinkedIn, obviously involved a large amount of consumer data, LinkedIn's consumers, but Microsoft had to understand how to value the deal. And so an exchange of that data would have happened during due diligence. LinkedIn and Microsoft would have entered into a data sharing agreement that accounted for, limitations in Microsoft's use of the data, that aligned with LinkedIn's permissions. It also would have addressed things like deletion requests, kind of the elements of the data sharing agreement on this slide here, right, would have been taken into consideration in a transaction like that involving a large volume of consumer data. A different kind of transaction, like a private equity firm's acquisition of a cybersecurity company, the data sharing agreement might look a little different. The reasons for wanting to evaluate data are different there, right? In the example involving the cybersecurity company, the buyer wants to understand the technical integrity of the ecosystem of its target, potential vulnerabilities of that cybersecurity infrastructure, and for the purpose of assessing potential liabilities, post-closing costs associated with addressing them, for example. And because of the nature of the data required to conduct those types of due diligence assessments, the data sharing agreement would take into account any limitations around the sharing of third-party data or other regulated data involved in conducting that assessment. Even something that spans across industries. Company A acquires Company B, and pre-close needs to coordinate employee benefits, payroll, retention strategies. That necessitates access to employee personal data, right? Names, roles, salaries, benefit elections. You could have a DSA in that scenario that provides structure around what data is shared when, how long it's stored, how long it can be retained, those types of things. So multiple different contexts, the data sharing agreement can be a tool to supplement your NDA and the protections it can provide during the deal. Luke, do you have anything to add there?
Other than to say that I'm a big fan of DSAs, and I guess for the lawyers on the call, if you need to convince your business folks about why a DSA is necessary on top of an NDA, because we understand, certainly it's an additional cost, it's additional time commitment. We hope this has been helpful because they really do serve different purposes. The NDA's main purpose is confidentiality. The data sharing agreement's main purpose is to make sure that you're complying with regulatory, but also your own internal policies relating to the PII that you've collected from consumers and that you're now proposing to share. So they do serve different purposes. And again, I think certainly getting in writing and limiting in writing what the target or the acquirer can do with data that you've so carefully collected in compliance with a whole host of laws is really, from a regulatory and a litigation perspective, just a really, really good thing to do. So along those lines, as I said earlier in this call, I am a litigator. So my role in these types of deals, M&A deals, most of the time is to identify red flags. And to me, red flags means, at least in part, what about this agreement, what about this deal, what about the data collection and sharing might lead to disputes, litigation, or regulatory concerns, and having identified those, what can we do to mitigate any of the risk that a particular transaction creates. So we've provided a list for you of potential red flags that might come up in a transaction. I'm not going to go through all of them, but I am going to focus on two that I think are particularly important. The first is no personal data inventory. If you're in the position of the acquirer, and the first question you ask the target is, what types of personal information have you collected, do you store, and where? And the answer is, we have no idea. That's a red flag. So there's at least a potential concern. So there's currently in the U.S., and in addition to laws outside of the U.S., as Brittney mentioned earlier, we have a patchwork of 20 different state laws that all in some way define personal information. And to make it a little more frustrating, some of these laws define personal information slightly differently. For example, whether employee information is covered, whether business-to-business information is covered, as well as whether GLBA, Gramm-Leach-Bliley, or HIPAA information, how it's covered. It can also vary state to state. If a company doesn't have a good idea of what information it holds and whether and how that information is subject to these various state laws, that's a pretty significant task that it might be difficult to undertake and try to get done in the due diligence process itself. So it's certainly not that it can't be, but certainly if a target, again, can't account for the information that it has and how it collected it, that's certainly a concern. The other one that I want to highlight is prior data breaches. And really that's more from a due diligence perspective of understanding the basis to prevent future similar issues. So and I guess before I get into that, understanding that some data breaches, including sophisticated hacking, are almost now a cost of doing business. There's some types of hacking that the most expensive and best cybersecurity programs might have difficulty catching. Social engineering is obviously very difficult to control. So this is certainly not to say that if a target has been the subject of a data breach, that itself is determinative. It's not, and the best and most secure and biggest companies have been breached. But if a company discloses a data breach, and the data breach is, I guess what I'd call among the more mundane types of breaches, for example, physical security issues, lack of training for key employees on cybersecurity risk. Digging into the cause of, I guess, subject to what the company is willing to disclose, but digging into the reasons behind disclosed breaches or security incidents can be really helpful in due diligence to try to figure out additional problems that might have existed, and even more importantly, what the company did to remedy them. I think you can learn a lot about and sometimes a lot more about a company's cybersecurity by looking at and compliance with consumer privacy laws, by looking at actual examples of what happened as opposed to representations about how wonderful the company is doing in terms of in those areas. So we've identified some red flags, or we think there might be some red flags. So what can we do as part of the transaction to get ahead of them to mitigate? And again, we've provided a list for you of certain things you can do. And again, I'll just focus on a couple for the presentation. So the reps and warranties we'll talk about in a minute. So I'll set that aside for now. I think the most, at least from a litigator's perspective, it might be a litigator's favorite contract term, certainly the most often, maybe not omitted, but the most often discussed from my perspective, agreement term relating to consumer data privacy and security is indemnification, which is the second bullet point, seeking an appropriate indemnification in the event that either data was not collected in accordance with laws for security incidents or any other breaches of the reps and warranties. And on that point, I will say that you can negotiate and typically do negotiate indemnity provisions, and certainly it's subject often to the parties' relative bargaining power as well. But these terms are negotiable. You can, for example, negotiate the trigger for the indemnity in the event of a breach, or in the event that turns out that data was not collected in conformance or in compliance with applicable laws. The trigger can be as simple as a breach of a rep and warranty. That's the trigger. You breached a warranty, full indemnity. The trigger could be negligence. You breached a warranty through negligent conduct. A little bit higher standard, I guess, for the target than a simple breach of the warranty. You breached the warranty through grossly negligent conduct, and even higher standard. So I guess the point is that indemnity is itself negotiable, but it really is, it certainly can be tremendously important as part of a deal to align or to get the parties, to set the parties' expectations about who's going to be footing the bill in the event something happens. The other point I wanted to talk about here is the last one, developing a comprehensive post-completion privacy program for the target. Again, I think that's really important because there's different ways to go about that too. Is the end result of the transaction going to be that the target company comes into compliance, ideally, with the acquiring company's privacy programs? But are there additional things that the target company, as part of the acquisition or shortly after the acquisition, intends to do? And I think that also can tell you a lot about a target company. From a risk mitigation perspective, obviously critical that any issues are fixed, but can also tell you a lot about the target company's ability to fix some of the issues that may have arisen. If the question is, what are you going to do to fix issues 1, 2, and 3? And the answer is dead silence. I think that can tell you a lot about the potential liability that you might be undertaking as part of the deal. All right, I think we've reached our first secret word of the day. So the secret word is book. And I will wait a couple minutes, I guess, to make sure everybody has a chance to click it. All right, I had a little thing up that told me how many people had responded, but that disappeared. So I'm going to take that as most people have responded. Maybe another minute. Okay. All right, so a couple slides ago, we talked about the reps and warranties. So I think for most folks on the call are going to be familiar with the concept of rep and warranty. It is a representation that one side makes to the other with the intent to assure the other side that certain conditions and certain factors have been met. So what do reps and warranties generally do? As it states here, they allocate risk. They clearly define which party bears the responsibility for specific cybersecurity risks. I would include in that also risks relating to consumer privacy issues in terms of collection and sharing of certain information. As I said, indemnity is a huge part of that and typically negotiable. Providing legal recourse, offering the buyer specific remedies. This is also a very often negotiated provision as to what the specific recourse is, and even more importantly, what the remedies are, and whether negotiated as part of an indemnity provision in terms of or in the context of a limitation of liability provision. You need to understand in the agreement not only what your recourse is, but what the potential recovery, damages, et cetera, may be. And obviously insurance plays a part in that too, but your agreement needs to provide legal recourse and define what that legal recourse is, including whatever damages may be available or may not be available if you're the party trying to limit. The third one I think is I don't want to say the most important, but is definitely very important for me. A key function of reps and warranties is that they encourage disclosure. And on that point, I think as a practical tip, I found that the more detailed the rep and warranty, the more likely that it can be relied upon. And which kind of goes against the grain in some cases, because as the acquirer, as a party to whom a rep and warranty is made, I think the common approach is, well, get the broadest rep and warranty you can. We comply with all laws that might possibly ever apply to us for all time. And if we breach them, or if we don't, then it's a breach of this rep and warranty. And while such a rep and warranty can certainly is the broadest and might capture the broadest swath of defined claims, it doesn't always guarantee that the party making the rep and warranty actually went through and thought about what specific laws might apply, whether they're complying with them, and is confident in making the rep and warranty. So it's kind of a double-edged sword where, again, I found if you ask for a warranty specific to a subset of personal information, and that subsets or the company's compliance with respect to how that information was collected and how it's shared, I think you're going to get a better, even beyond, the disclosures to the questionnaire, I think you're going to get a more thoughtful response when somebody is on the hook, not just to make a representation, yeah, we think we comply, but a specific representation. Yes, we've collected this subset of data in compliance with the following laws, whether it be GDPR because it's from EU residents, or CCPA because it's from California residents. Again, if you put somebody through those motions, I think you're going to get, often you're going to get more reliable responses. So what types of reps and warranties should you consider? The first one was just what I just talked about, compliance with laws and regulations. Again, consider both the broad, we comply with everything, and more detailed, we comply with X as relates to Y. Adherence to privacy policies. I think that for this one, again, I'm not going to necessarily go through every one of these. The one I want to focus on is legal actions or claims. I think most acquirers in key deals have the ability to search dockets and figure out what legal actions a company might be involved in, including as relates to consumer data privacy issues, which I think most folks on this call probably know can be tremendously costly and a huge line item, a huge cost item as part of a deal. What that might not capture, or that wouldn't capture, is claims. And I'll give one example that's near and dear to my heart because I've been dealing with these cases for the better part of a couple of years, which typically start as claims and might not develop into litigation for months or even years. So there's a ongoing trend of data privacy litigation in California, primarily in California, but in other states as well, addressing website tracking technology. So these lawsuits filed by a handful of firms, although that handful is recently expanded, but filed by a handful of firms who allege that website tracking technologies violate wiretapping laws, so that it is a form of wiretapping for you to use tags, cookies, pixels on your website and share website visitor information with marketing or other partners. Again, that's alleged to be a violation of wiretapping laws. The reason that I think, and well, I'll add one more thing. While a lot of these cases can go away for not a lot of money, many of them have also developed into years-long, very costly, millions of dollars of legal expense litigation, especially when healthcare or financial information is involved. Many of those claims start with a letter that says, we have a website visitor who is alleging the following violations, and only after a couple month process, or in some cases almost a year process, does that develop into litigation. Again, this is near and dear to my heart because we've handled quite a few of these, and not asking the question, especially if the acquirer is a commercial retailer, operates a commercial website, not asking the question of, hey, have you guys been the target of this already? Is this something you've already gone through? Is this something that you've already taken a look at, settled maybe, or at least taken a look at your process? I think would be really problematic given how much money these can actually take. So I guess the punchline is, don't limit the legal actions to lawsuits. Don't gloss over it. If you're asking an acquirer, if you're asking a target company, have you been the subject of claims, make sure you have some understanding of what the potential claims might be, which again, your litigation lawyer can help you with, and ask those questions and get the right rep and warranty relating to the questions that you actually want to answer. So with that, I will turn it back over to Brittney for post-closing integration.
I'll let Matt take this one.
Sounds good. No, you're good, Luke. And one thing, just to add on to Luke's thoughts on representations and warranties too, obviously not to state the obvious, but I think it's worth stating. If you are on the sell side, obviously it's imperative that you not only read the representations, but make sure that you read that privacy and data representation in full. I can think of a situation a few months ago where we were working on a sell side deal, essentially a spinoff, and our client was essentially a contract manufacturer. And I think, within the medical device world, let's call it. And I think buyer had some indication or understanding that our client received personal health information or personally identifiable information. And it just was not the case that we ever received that information. We would receive specifications from third parties as it relates to making products, but that information was not ever received nor reviewed nor accessed by our client. So we obviously had a pretty lengthy conversation with the buyers about that, but most importantly, that rep was removed and the scope of that rep was substantially narrowed, and obviously mostly because our client was not ever privy to nor should be making a rep to information that they are not privy to. So I just wanted to add that to Luke's good assessment on the reps and warranties in a transaction setting. Okay, so I will touch on this briefly, but generally would like to chat about just post-closing integration and risk mitigation as it relates to data security and data privacy. So from my perspective, in essence, I would say if you're kind of like halfway through the transaction generally from a timing perspective, I think that is probably a very appropriate time where you should have a really good understanding as it relates to what integration will look like on a post-closing basis. And the reason I say that is this. At that point, diligence has probably been conducted substantially enough where you understand the systems, the software, the information that the target has, and you probably have an understanding of where that information and data sits for seller and where that information would need to sit for purposes of buyer post-closing. And I think the ultimate question is, to an extent, do you need a transition services agreement in place for some period of time to have a buffer or gap for a 3 to 6 month period after closing that allows for buyer to have some sort of ramp up period to make sure their systems and their programs are able to take on the information and the data that seller is trying to provide. And obviously, from my experience and from my perspective, those transition services agreements are very business specific, right? I would say most of the time the contents and the provisions of a TSA itself are pretty straightforward, but there are, again, I think there are material business implications, right? Because there are costs likely that are going to be incurred by buyer if seller is going to be providing some sort of bridge services for a 3 to 6 month period after closing. And obviously it is typical and likely that there may be some escalators in terms of cost if buyer is not able to get this information onto its platforms after 3 months. Maybe seller starts charging a bit extra for the services that it is providing on this post-closing basis. So to me, I think post-closing integration is usually something that clients and businesses maybe think about too late in the process. But if you can have those conversations with them, like I said, more in the post-diligence phase. I know diligence technically never ends, but if you've got a really good understanding of the business, I think you'll have a good understanding as to how this information and the data can be transferred and processed to buyer. I think another key important thing is obviously when it comes to information that is being given to buyer, if there is some sort of triggering mechanism from a regulatory federal state perspective as to, hey, we need to give notice to a specific regulator. Hey, we have to give notice to the data subjects that this transaction has taken place. And then I think just as important too, obviously, is understanding the full landscape of the information. Because I think sometimes, even from my perspective, I think about it from information technology in the systems. I think about the information and data maybe that is related to the customers or the vendors. But I think we also have to be privy to, hey, this will probably incorporate and relate the labor and employment department of your client. This could include the employment benefits department of your client, right? They may be receiving specific information, personal information regarding certain individuals that may now be an employee of buyer and is now part of buyer's employment benefit plan. So I think, again, from a high level perspective, in my opinion, there have to be conversations from a business perspective about how that data is going to be integrated, and can it be integrated on day one? Are there going to be disruptions to the business if this is not done on day one of closing? So those are just some factors to keep in mind. And then I think, overall, I think this slide is kind of just a really good, helpful resource for items that you should keep in mind from an integration perspective. I know Luke already talked about, obviously, how do the policies and procedures of seller and buyer differ? And are buyers' policies and procedures above and beyond what is required from a legal or regulatory perspective, right? Maybe there's a higher standard that a buyer has relative to the legal and regulatory landscape. I think data flows and getting those maps are incredibly important as well. I think it's helpful to understand the mapping of IT systems generally too. Sometimes what I've seen is there will be an entity that receives all of its IT services or frankly all of its services from a parent company, right? And then you have to understand how does the parent company provide and transmit and collect and store all that information on behalf of the subsidiary, and how is that going to affect the transaction on a go-forward basis? So again, I think this slide is a very, very good snapshot of things that should be thought about when it comes to integration. But again, most importantly to me, start thinking about having those integration conversations with your client sooner rather than later. I know it's difficult to do because there's like 1,000 things going on, but I would say keep it top of mind on a go-forward basis. And with that, I will turn it over to, I think, Luke and Brittney to discuss Microsoft and LinkedIn.
Thank you. Yeah, I'm going to kind of take this discussion off the top. So Microsoft's acquisition of LinkedIn took place back in the end of 2016. Something I'm going to note kind of at the top of the conversation is, as far as the regulatory landscape at that time goes, GDPR had been enacted but was not yet in effect. It didn't come online until 2018. The first iteration of the CCPA also came online in 2018. So I think something to keep in mind as far as my analysis of taking this case study through kind of the deal process is a lot of the considerations from a data privacy standpoint are going to be kind of seated in modern time under the law as we see it today to give the most benefit right to our audience. And I'm going to have to do this a little bit quickly. But okay, so obviously everybody is familiar with Microsoft and LinkedIn. Microsoft acquired LinkedIn with the hope of tapping into the 433 million users of LinkedIn at that time to enhance its own existing suite of products and services. Microsoft also had a vision to enhance LinkedIn's behavioral ad tech capabilities. And so with that, they entered, into kind of the process that we're talking about here. I'm going to reconstruct kind of how we would imagine the due diligence process went, because obviously it's a confidential, the kind of the details of that are confidential. But Focusing just on a few of the pre-transaction due diligence points listed on the slide, given the large volume of consumer data that that would have been an issue. Obviously, we would be thinking about a data sharing agreement here, in addition to an NDA, as Matt talked with us about. So limitations around kind of Microsoft's ability to use and process the data in compliance with the regulatory framework. That would involve data mapping and inventory on the front end, understanding what LinkedIn had, how it was allowed to use it under the consent architecture that existed at that time, and kind of LinkedIn's own policies and practices. With a data sharing agreement in place, Microsoft's obviously taking a look at the data and looking for all of the red flags that we have discussed, right? LinkedIn's practices with regard to how it tracked and used behavioral data of its customers is kind of, I think, the most relevant for our discussion today. And I want to pick on it a little bit because there are issues that arose there down the road. So just last year, LinkedIn was fined by the Irish Data Protection Commission in the amount of 310 million euros for violating GDPR rules on consent for ad targeting. So again, as we talked about, the acquisition occurred before GDPR came online in 2018, and the claim itself arose just after GDPR was enacted in August of 2018 is when the claim against LinkedIn for its data practices arose. But just as a lesson learned here, I think, again, given the regulatory landscape at the time, Microsoft may not have been looking for all the things we know we need to look for in due diligence today. But if it could, go back and do it right, I think Microsoft could have done a better job of examining LinkedIn's policies, consent architecture, and third-party vendor contracts to ensure that those items were in compliance. And then even if they were not, Microsoft could have valued the deal in a different way to account for those post-acquisition costs. It could have gotten those specific reps and warranties if it had known the questions to ask around, the permissions LinkedIn was getting from its users, and how it was then actually using the data and kind of seeking a representation from LinkedIn that it was not only in compliance with the law, but also with its contractual obligations. Another representation that could have been sought would have been with regard to LinkedIn's compliance in vendor contracts as well. And then, okay, sorry, I just lost my train of thought there. But yeah, I think the lesson there is just, it can be, quite expensive to fail to account for, overlooked non-compliance issues, and it impacted ultimately, how the deal and the information maybe should have been valued by Microsoft during the deal process. I could talk a little bit more about this and kind of in my head as I'm talking, debating about whether I want to continue the discussion, but I also want to leave time for any questions if they exist. So I don't know if the audience does have questions about this specific case study or anything else that we've talked about. And before I forget as well, we have one more secret word to get through. So quickly, today's second secret word is clock. And please select that when you can. Again, the secret word is clock. few more seconds. Okay. I skipped over this slide to get to the secret word slide, but these are key takeaways from the presentation. And yeah, I'll just open it up to questions. I know we're a little over time or kind of right there. So if anybody has any. We can give it one more minute. Okay, I haven't seen any questions pop up, so I hope that you all got some value out of this discussion today. It was obviously brief and we were a little bit crunched for time on the substance, but please engage with any of the three of us to discuss further if you have questions or any comments. Thank you for your time.
Thank you.
Thank you, everybody.